Hi, my name is Hailey Carlson, and today I'll be talking to you about false advertising and deceptive labeling laws and their legal relationship to business, specifically in relation to food labeling laws. To start off, there are two major questions that need answering. The first, what is false advertising? And second, what constitutes deceptive labeling? Right now we're going to focus on false advertising, but we'll address deceptive labeling in a little bit. The legal definition of false advertising is any advertising or promotion that misrepresents the nature, characteristics, qualities, or geographic origin of goods, services, or commercial activities. A very basic example of false advertising can be applied to this monopoly money pictured here in the right-hand corner. If I advertise this money as being actual legal tender for use in the United States, I would be misrepresenting the quality of this good as being more valuable than it actually is. And to elaborate a little bit more about false advertising, we'll talk about the three major types: failure to disclose, flawed and insignificant research, and product disparagement. Failure to disclose is defined under the Lanham Act as representation through advertising that is untrue as a result of the failure to disclose a material fact, meaning that if a company knowingly lies about their product in any way trying to mislead consumers about their product or service, they are failing to disclose something these potential consumers should know. There's a line between sufficient and insufficient disclosure, which is determined by the courts. This act does not require full disclosure, however, but if a company is clearly misleading in their ads, it is false advertising due to failure to disclose. The second of these types is flawed and insignificant research. This is also covered in the Lanham Act and happens when advertisements are just blatantly incorrect. This sort of false advertising essentially is when people either make up facts off the top of their head, they use sources that are unsupported by significant research such as Wikipedia, or their facts are completely contradictory to common authority. And the last of these is product disparagement, which is essentially when companies lie about their competition in order to make themselves look better. Now that we've addressed the different types of false advertising, it's time to go back and address our second question from before that said, what constitutes deceptive labeling? And first to define this, we'll need to look at 15 U.S.C. section 1452, which deals with the scope of prohibition of unfair and deceptive packaging and labeling. This basically states that it is unlawful for people to package or label any consumer commodities for distribution in commerce while knowing in good conscience that the label advertised does not accurately represent the product or service being sold. Now that we've addressed those two major questions, it's time to look at a case that involves the terms that we've defined. Naked Juice, an American fruit and vegetable juice and smoothie company, a subsidiary of PepsiCo, faced a class action lawsuit in August of 2013 due to false advertising. The issue came about because the company was deceptively labeling products as things such as 100% juice, 100% fruit, from concentrate, and all natural fruit. The biggest controversy was the lawsuit takes issue with these phrases specifically because it claims that Naked Juice products do contain artificial or not all natural ingredients, and they also contain GMOs. The company and its mother company, Pepsi, remain firm in the fact that their products are non-GMO. However, they have since taken the phrase all natural off of their juice and smoothie labels, as I said in the Facebook post, and until there is more detailed regulatory guidance around the word natural, we've chosen not to use all natural on our packaging. Despite these claims, the company settled for $9 million and paid out to customers who purchased their drinks between September 27, 2007 and August 19, 2013 for up to $75 with a receipt and $45 without. The type of false advertising at play here is flawed and insignificant research, which is evident in their Facebook post that states that they use the word natural without fully knowing what it meant. Another food-related instance is evident in the court case Palm Wonderful LLC versus the Coca-Cola Company. The case came about because of what Palm Wonderful describes as misleading labels on Coca-Cola's Minute Maid juice called pomegranate blueberry flavored blend of 5 juices. The people at Palm Wonderful had a few concerns with this product. First off, this pomegranate blueberry juice contains only 0.3% pomegranate juice, 0.2% blueberry juice, and a 99% mixture of apple and grape juices, and yet this is still called pomegranate blueberry juice. This leads to their second biggest concern, which is the label of this drink. One would think, looking at the picture on the right, that there would be much more pomegranate and blueberry juices than anything else, seeing as those are the biggest words in that flavor area of the bottle. The words flavor blend of 5 juices are significantly smaller and harder to read compared to the text above them that reads pomegranate and blueberry juice. Doesn't this mean that Coca-Cola is misleading us? Well, Coca-Cola's defense is that because their labels are FDA compliant, they cannot be illegal. Supreme Court Justice Sotomayor agreed that the use of this juice name is permitted under regulations, but asked the Coca-Cola representatives, why are you permitted to use it in such a misleading way? If you're using the name in combination with other factors in a misleading way that's not subject to the regulation, then it's actionable under the Lanham Act. The major issue with this case is whether Coca-Cola can be guilty of false advertising when their labels are FDA approved. The court found that the FDA and the Lanham Act discussed earlier are meant to be complements to each other, meaning that though something may be legal under the FDA, it can be misleading in its advertising and thus illegal under the Lanham Act. So with so many cases like these going on, it's obvious that our lawmakers are trying to help prevent false advertising of our products. But in the meantime, what can we do to help ourselves? Well, there are a few things that we can do. First, we need to read labels very carefully. As we saw in the last case, some of the most important text was actually the smallest, and we need to just make sure that we're looking for those things. Second is being aware of different legal statutes. Again, in the last case of Palm Wonderful LLC versus the Coca-Cola Company, there were 2 different statutes at play, the FDA and the Lanham Act. So maybe if we're all aware of these things, we'll be able to be better knowledgeable in the future. Also, if we pay attention to class action and other lawsuits in the news, then we'll be able to be aware of these things. I found out about the Naked Juice class action lawsuit while I was working for a company that sold their product. So I hope that you enjoyed learning a little more about false advertising and deceptive labeling today, and here are my sources and my image URLs. Thank you very much.